The Supreme Court decision in the case of ELMER Padua versus People of the Philippines. Case law states that the testimonies of child rape victims are generally entitled to full faith and credence, considering that when a woman, especially a minor, says that she has been raped, she says in effect all that is necessary to show that rape was committed. Youth and immaturity are generally badges of truth and sincerity. It is also settled that the credibility of a child survivor is augmented when she has no malevolent motive to testify against the accused, or where there is absolutely no evidence which even remotely suggests that she could have been actuated by such motive, as in this case. A.K.A.'s version of the events was likewise bolstered by the Medico Legal Report, which found the presence of erythematous and laceration at 3 o'clock position of her hymen. Indeed, the findings of Dr. Guzman showed evident signs of trauma, which were consistent with A.K.A.'s allegation of sexual abuse. To be sure, we have previously ruled that when a rape victim's testimony on the manner she was defiled is straightforward and candid, and is corroborated by the medical findings of the examining physician, the testimony is sufficient to support a conviction for rape. With the evidence, the Supreme Court is unable to give credence to petitioner's theory of infantile amnesia, which supposedly made AAA unable to remember events at the age of 3. In People versus Magbatang, this court clarified that our earlier ruling in People versus Jesus only referred to the childhood amnesia theory as a plausible explanation for the inconsistencies in the declarations of the victim because of her very tender years. As the burden still rests on the party objecting to the competency of the witness to establish the ground of incompetency, the accused must still present proof of the witness' mental inability to perceive and make known such perceptions, to successfully interject the theory of infantile amnesia. However, in the instant case, ELMER merely relied on his own allegations of inconsistencies in A.K.A.'s testimony without submitting any evidence on her purported intellectual incapacity. Meanwhile, the inconsistencies in AAA and BBB's respective sworn statements and testimonies that were enumerated in the petition deserve scant consideration. The alleged disparity in the testimonies of AAA and BBB may be attributed to the fact that their sworn statements were made in June 2014, and they did not testify in court until around 3 to 4 years later. On the other hand, courts are to expect minor inconsistencies when a child victim narrates the details of a harrowing experience like rape. We have also observed that sworn statements are almost always incomplete and inaccurate and do not disclose the complete facts for want of inquiries or suggestions. Hence, as a matter of judicial experience, an affidavit, being taken ex parte, is generally considered to be inferior to a testimony given in open court, as the latter is subject to the test of cross-examination. Nonetheless, the Supreme Court agreed with the Court of Appeals that the variance in the date when AAA reported the incident, and in the circumstances and condition upon which BBB found CCC, DDD, and AAA after the incident, relate to extraneous matters that do not affect, much less negate the material points of the crime charged. Such inconsistencies on minor details are in fact badges of truth, candidness, and the fact that the witness is unrehearsed. These discrepancies as to minor matters, irrelevant to the elements of the crime, cannot, thus, be considered a ground for acquittal. In People versus XXX, we held that the trial court stood in a much better position to decide the question of credibility, having seen and heard the witnesses themselves and observed their behavior and manner of testifying. It bears stressing that trial judges are in the best position to assess whether the witness is telling a truth or a lie, as they have the direct and singular opportunity to observe the facial expression, gesture, and tone of voice of the witness while testifying. As such, their evaluation on the credibility of witnesses in rape cases are generally accorded great weight and respect, unless it is shown that the evaluation was reached arbitrarily, or that certain facts or circumstances of weight, substance, or value which, if properly considered, would alter the result of the case, were overlooked, misapprehended, or misappreciated by the court. Notably, petitioner's defense of denial fails against the evidence of the prosecution. His testimony stating that he had been cooking rice and vegetable viands during the time of the incident was unsubstantiated by any proof. His plain denial, which is negative self-serving evidence, cannot stand against the positive identification and categorical testimony of a rape victim.